this is kind of a work in progress that builds on work that I've done in the past and work that I hope to do in the future about whether or not environmental justice can be achieved through using pre-existing mechanisms at the international level that were specifically designed for communities in developing countries seeking to challenge development projects that are being financed by multilateral development lenders. So essentially what I'm going to do today is to talk through what these mechanisms are and how they are being used and whether or not there is some potential to address the looming biodiversity crisis and or the current existing biodiversity crisis and how and if species are recognised in this process. So what are the multilateral development banks undertake development financing. Most well known is the World Bank, but all of the regions have their own banks: the African Development Bank, the Inter-American Development Bank, European Bank for Reconstruction and Development. These are the large regional development banks. There are, of course, sub-regional development banks and micro development banks as well. And the reason why I focus on the multilateral development banks is because they are considered the model and the norm diffusers of best international development financing practice. And so what I've done is to look at how they, in my previous work, look at how and why grievance mechanisms were created for these multilateral development banks. And some of you may be familiar with the Narmada Sardar Sarovar Dam that really kicked off in the 1980s. Plans in India started in the 1960s to build a construction of mega dams across the 3 states of India. And this led to one of the largest civil protests in India against the dam because of the impact on communities and on the natural environment. And this protest, it was financed 2 loans by the World Bank, and it became the big galvanising action against development financing from these multilateral institutions that really didn't take into account the environmental and social concerns at the project site. So this essentially kick-started the idea that there should be grievance mechanisms where people could complain about projects being financed by the multilateral development banks through a loan to the Indian government. And so all of the banks over a 10-year period created grievance mechanisms. So the most well known is the World Bank's inspection panel. And essentially this is what they call citizen driven, which means that if communities feel like they haven't been adequately consulted, they haven't participated in this decision, that they can then go to the mechanism after they've complained to the World Bank and perhaps had no recourse. They can then go to these mechanisms and demand that the banks investigate whether or not they have fulfilled their environmental and social policies. So what I've done over the last 2 years is there a way to, okay, over here. Yeah, can you just pull it up? Of course. What I've actually done over the past 2 years is to look at all of the claims made by people against the multilateral development banks. And so I've done the sort of big regional development banks, the World Bank and the World Bank Group. Can you go to the African Development Bank? Thanks, Gemma. And so what the mechanisms do is provide recourse. This is not a means of redress. And this is what I really want to emphasise here is the entire basis or rationale is to listen to people's grievances and seek to rectify them where possible, but within the constraints of the project. So the project's already been designed, supposedly with community participation. The project's already been designed, and then as it is being undertaken, as the dam is being built, for example, this is when communities may have grievances that they then take to bank management. And if bank management do not address these in a timely fashion, they can then go to this grievance mechanism. So in the instance of the World Bank Inspection Panel, it's 3 people that are independently appointed to investigate people's claims. And so the claim can only be done while the project is being financed by the bank. It can only be done while the project is being undertaken. So if the dam's already near completion, you're probably not going to get any redress whatsoever. But if it is being financed, still being financed or in preparation for being financed, you can take your claim to these mechanisms. And of course, there are some very high hurdles to meet. In the beginning, a lot of these mechanisms expected that it would be in the official language of the bank, or in English, in the case of the Asian Development Bank, which is a curious one. And you would need to demonstrate the harm that the community or the environment was suffering. You would need to identify which specific environmental and social policy was not being fulfilled. So there was a very high bar for access for communities to be able to make a claim. But a number of claims over the time have been undertaken. So this is freely available on my website if you're interested in tracking through what happens to people that make claims. And that there's over 1,000 claims that have currently been lodged. And what I've done is identify what happens to a claim. So most of them are just not registered. This means they haven't met the basic criteria. That is, maybe they haven't gone to management to complain first. Maybe it's a project not even being financed by the bank. If it's not registered, that's it. But if it is eligible, it meets these minimal criteria, then it will go to the assessment period, which is a more formal analysis of whether or not there is a possible link between this project being financed by the bank and harm. If it meets the assessment period, it then can go into two ways. This is a specific bifurcation of the mechanisms because originally they were only based on a compliance investigation. Yes, no, did the bank follow its own environmental policies or not? And did this lead to harm? And communities had no role, absolutely no role in this process, which essentially meant that it became a technical fact-finding analysis. Could we identify harm as a result of the bank's omissions or inactions? Now, communities protested this. Funnily enough, so did the private sector. They didn't want compliance investigations into some of the co-financing of the development projects that were being undertaken. And so over time, we see a shift to mediation. So now communities have the right to ask, we would like to mediate, we would like to sit down and talk about how to rectify these problems with the bank and usually with the government undertaking the project, executing the project. So it can either go to mediation, where the community participants or the claimants get to sit down and discuss how to rectify the problem. If that fails, they may then choose to go to a compliance investigation. There's a distinct difference. Some communities know that there is absolutely no way they can sit down with the banks and with the government because they have, in many cases, come to quite extreme standoffs in what the community wants compared to what the government and the bank wants. So some go automatically to compliance and some try to mediate. So what I've done, and I was really, really pleased to be invited to talk here today, is to think through how this affects the environment separate from people. And to be honest, most of the claims do fit within an environmental justice rather than ecological justice rendering. And this is because most of the complaints are about capabilities and being able to fully function when your land has been taken away, when you no longer have access to fishing, when you no longer have access to livelihoods. So a lot of the claims are about capabilities, and they're also about the distribution of benefits. The fact that communities are giving up quite often their livelihoods for a national development project, a power plant or what have you, and they're not seeing any of the benefits. So I was struck by identifying that only 7% of the claims that have gone to all of these mechanisms over a 25-year period actually identify species loss or biodiversity as a key concern. So this is independent of, and often in addition to, the claims that they are making about accessing a loss of livelihood and more immediate distribution losses. And so I started to think through, well, what does this mean? Because this is a very small part of the big development picture where projects continue even while these claims are ongoing, which means the dam is still being built while claimants are going through an investigation. If you go through mediation and investigation, you can talk up to 7 years. And some of the banks, like the Inter-American Development Bank, are very good at staving off any decision, which means for some claimants, they've been waiting for 10 years to know what's going to happen. Meanwhile, the dam is slowly but surely being built. So this is obviously not an ideal picture, and one of the biggest issues I have is trying to identify, well, what are the best mechanisms for communities seeking to protect their environment, particularly in ecologically fragile and sensitive areas. Is this actually worthwhile? Because species habitats continue to be lost during this process. So I haven't been able to pull out all of the data that I'd hoped to about what happens to specific species that have been identified, but I can tell you that most of the projects do end up being built, and they are built in exactly the way that they were initially intended. And so what I basically just want to finish on is this idea that this is perhaps best understood through an environmental justice rather than an ecological justice frame, specifically where most of the claims identify that the issue is that they have not even received any recognition, that they are part of, or should be part of, the development decision about where a dam should be located, where a power plant should be, that they are not informed. This is probably one of the biggest takeaways of the research that I've done, is that most of them don't even know who is financing this project, who made the decision, why it was determined. That's the number one claim that communities make, is that they just aren't involved. They just have no idea what's happening. So participation in the process and recognition of their right to be involved in the process is one of the key claims that they make. Distribution of risk and benefits follows through, particularly, but not limited to, economic distribution of benefits, because they identify a whole range of other issues that concern them in terms of loss of spiritual sites, particularly in areas which are not recognised by governments and therefore are open to development. But these are obviously infringing in quite often ecologically sensitive areas, and it's quite surprising, I think, almost that that species don't have more of a role in this. But perhaps this is because of the way in which the institutions were designed. But I do want to end on a positive note. So I can say that in some instances, like in cases against the European Bank for Reconstruction and Development, there is the possibility of wins. And they actually come through preempting the process, knowing which projects are on the horizon. And particularly environmental groups have been very successful, 2 cases successful, of being able to stop a project before it even gets started. And these are projects where the EBRD, in conjunction with the governments, have actually tried to begin mining in biodiverse, really rich biodiverse areas that do have protections already. So sort of, I guess, worst case scenarios that have been stopped. So that's just some of the ways in which we can think about the options or alternatives for trying to protect species with pre-existing mechanisms. So I'll stop there.